Hey everyone, and welcome. Today we are diving deep into a really important safeguard inside India's new criminal justice system. We're talking about the power of revision under the new Bharatiya Nagarik Suraksha Sanhita, or BNSS. Now, this is basically a vital check and balance, one that's designed to correct legal mistakes. So we're going to break down exactly how it works.
So let's just start with a really fundamental question. What happens if a lower court just gets a decision wrong? Maybe it's a flawed finding, an illegal sentence, or the procedure they followed was just improper. Is that it? Is that the end of the line? Well, that's exactly the problem that judicial revision is here to solve.
The best way to think about revision is as a kind of built-in quality control system. It's the power of the judiciary to take a second look at a case. And this is important. It's not about retrying the whole thing from scratch, but about making sure everything was done correctly and fairly the first time around.
So at its very core, revision is a supervisory power. It literally allows a higher court to call for the case file, the record from a lower court, and just examine it. And the whole goal here? It's to prevent a serious miscarriage of justice by catching any major errors in law or procedure.
Now, you might be thinking this is a brand new idea, but it's really not. While the law's name is new, the concept has been around for a long time. This power of revision, which you'll find under Section 438 of the new BNSS, it directly corresponds to Section 397 of the old Criminal Procedure Code. So it's a well-established legal principle that's just being carried forward. All right, so who exactly gets to wield this power? Who gets to take that second look? Well, they don't just hand this authority out to any court. It's actually quite specific.
Under the BNSS, this pretty significant power is given to two higher levels of the judiciary, the High Court and the Court of Session. And it makes sense, right? These are the courts with the experience and the authority to properly oversee the decisions that are made by the courts below them.
So what do they actually do? Well, their main function here is to be able to call for the official records of a case from any subordinate criminal court that's within their jurisdiction. They are, in effect, pulling up the case file to give it a thorough review. But here's the thing. A higher court can't just step in whenever it feels like it. There have to be very specific legal reasons or grounds to even trigger a revision in the first place. So what exactly are they looking for when they pull that file?
And this really is the crucial question. What gives the High Court or a Session Court the justification to go in and scrutinize a lower court's judgment? The law is actually super specific about the criteria for this.
The whole point of this examination is for the higher court to satisfy itself on four key pillars. They're asking, first, was the finding factually sound? Is it correct? Second, was the order or the sentence itself even lawful? Third, was it fair and appropriate? That's what's known as propriety. And finally, fourth, was the whole process conducted by the book? This is regularity, just checking to see if the lower court followed all the required steps.
So, look, if you take away just one thing from this part, let it be this. Revision is all about ensuring that a decision was fundamentally fair, totally lawful, and followed proper procedure. It's the ultimate safeguard against arbitrary or just plain wrong decisions.
And if we boil it down even further, you basically have these two main triggers. Number one, the substance of the decision, the finding or the sentence itself, is found to be illegal or improper. Or, number two, the process was just flawed, the proceedings were irregular. If either one of those things happened, that's grounds for revision. Okay, so we've covered the who and the why. Now let's get into the how. What actually happens step by step when a higher court decides, yep, we're going to exercise our revisional power here?
So the process kicks off when those records are called for, but check out what can happen almost immediately. The higher court has the power to suspend the sentence. Now, this is critical. It means if the accused person is in jail, they can actually be released on bail while the whole revision process is going on. Then, after the record is examined, the final decision gets sent back down to the lower court to be implemented.
But wait, there's another powerful tool in their toolbox. If the revising court looks at the case and thinks the initial investigation or inquiry was just not enough, it can order a further, more detailed inquiry. And that gets handled by the Chief Judicial Magistrate, or CJM, who's a senior magistrate in that district. This power, which you can find in Section 439 of the BNSS, usually comes into play in two specific situations. Either a complaint was dismissed when it shouldn't have been, or an accused person was discharged way too early before the case was fully looked at.
In either of those scenarios, the law is absolutely clear. The accused has to be given a fair opportunity to be heard. Now, this power of revision probably sounds incredibly broad, and, well, it is. But it is not unlimited. The law puts some very important guardrails in place, defining what a revising court can and, crucially, cannot do. So let's do a quick recap of the wide-ranging powers these courts have. They can act a lot like a court of appeal, they can hit pause on sentences, they can order brand new inquiries, and they have to make sure the accused gets a fair hearing. These are all essential tools for correcting an injustice. Okay, but here are the really crucial limits. First, and this is the big one, a court in revision cannot turn an acquittal into a conviction. This is a fundamental protection. If someone has been found not guilty, you can't just flip that verdict through this process. Second, this power can't be used to challenge every little temporary order made during a trial, what the law calls interlocutory orders, because if you could, it would just bog down the entire system forever. There are also some key procedural rules you've got to remember. First, you get one shot. You can apply for revision to either the High Court or the Session Court, but you can't do both. Second, if the session judge makes a decision, that's it. It's final. You can't then go run to the High Court and ask them to revise the session judge's revision. And third, if the law allows for an appeal in your case, that's the path you're supposed to take. If you choose not to appeal, you generally can't just try to use revision as a backup plan. This line from our source material just perfectly captures that principle of finality. A revision of a revision does not happen. And that rule is so important. It prevents these endless loops of litigation and makes sure that at some point a decision is actually settled. And that brings us to our final thought for today. The power of revision is without a doubt a crucial safeguard. It's a way to correct errors and make sure justice is served. But does adding this extra layer of review also contribute to delays in a justice system that's already, pretty overburdened? It's a fundamental tension between being thorough and being efficient, and it's definitely something to think about. Thanks so much for joining this explainer.